There are two potential problems that could arise. First, an executive order could contradict an existing law or create new policies that are not already in place under the existing law. Both of these situations would mean that the president is exceeding the power of the executive branch. Secondly, an executive order could contradict the Constitution itself. If an executive order were to do one of these two things, the Constitution provides a system of checks and balances between the branches. The judicial branch is granted the power to intervene based on Article 3, Section 1, which grants judicial power to the courts in all cases arising under the laws of the United States. The landmark case of Marbury v. Madison in 1803 established a precedent called judicial review, in which the Supreme Court determines the constitutionality of laws, as well as executive actions. A number of executive orders have been struck down by the Supreme Court. One example is the 1952 Supreme Court case, Youngstown Sheet and Tube Company v. Sawyer, which involved President Harry Truman's attempt to seize control of steel mills during a strike in order to ensure production for the Korean War. Truman justified his order based on his constitutional power as commander-in-chief, but the Supreme Court ruled that the president had exceeded the power of the executive branch in this case. Other controversial orders have actually been upheld by the courts, such as Executive Order 9066, which authorized the forced removal and internment of Japanese American citizens. In any case, the ability of the judicial branch to review and possibly strike down executive orders is an important part of the checks and balances system and the division of powers within the United States government.